Okay, hi, and welcome back. Attorney Steve Vondran. Let's get to our presentation. We are talking in this video about common defenses in software audit, Bittorrent or torrent. There's lots of different sorts of peer-to-peer file sharing devices and copyright infringement cases. I'm Attorney Steve Vondran, licensed practice law in California and Arizona. We take federal copyright cases nationwide, software audits, threatening copyright infringement nationwide, and we offer free consultations. Okay, so let's get into it here. So we're talking about the types of defenses you might want to be thinking about. Sort of, you have these bullies coming at you. Copyright bullies are everywhere. They're in almost every area of digital content. So just about in this day, anything can be digitized. Books, movies, songs, lyrics, poetry. I mean, all kinds of things. As you see here, software. And these things can be distributed, shared. They can be uploaded to a torrent site. They can be shared and downloaded by the swarm, as they call it, the swarm. So there's all kinds of things. And we also have Etsy on here. We talk about them, where people can sell creative products. And there's lots of other websites, but where you can sell creative products, and then one person saying, hey, that product infringes mine, it looks just like mine. And so people are sending takedown notices and wanting to disable their accounts, for things like that. eBay is another example for selling things that people say that infringes my copyrights, my copyrighted work. Okay, so this PowerPoint is going to tell you a little bit about that, maybe some of the defenses, some things to be thinking about. This is not an exclusive list. These are just some good front mind items that should come to mind if you're basically faced with being put on the defensive with a copyright infringement lawsuit. Now remember, copyright infringement is usually, you can flag it very easy. Your letter, your demand letter, your copyright infringement notice will be talking about $150,000 in damages per infringed work, and that's actually the truth, and that's what it is. So you'll know by checking that out, okay? Things to consider when you're threatened with a copyright infringement. This could be a letter, this could be a takedown notice, this could be notice from your ISP that you've been served a subpoena and somebody's detecting you doing illegal downloading, for example, movies, Dallas Buyers Club, London Has Falling, adult videos with Malibu Media is a big thing. So my general first line, front line defenses is one, don't panic. Yes, okay, somebody's coming at you, they're threatening you with a ton of money. They may be threatening your business. If you're a business selling on Etsy, that could be a lot of money, and you could be saying to yourself, this may put me out of business. And if you're infringing and the plaintiff is aggressive, sure, it very well could. So it is important, but don't panic. Assess your options. How do you do that? Usually you're going to contact IP counsel. I hope this PowerPoint, which is not legal advice, I hope it provides you some general things to think about if you're facing one of these letters. And if you call us, of course, we can review your case and help you understand your copyright rights. Say that 5 times fast. Okay, so let's get down to it. Let's start with these torrent sites. These torrent sites are increasing. We are seeing a lot of lawsuit filings. We are seeing a lot of ISP subpoena notices where your internet service provider is being served with a subpoena telling you you're a bad person, you've been downloading or sharing their movies on websites like Bittorrent, these other websites. A lot of people that come to my office, they don't even know that Bittorrent's illegal. They go, what? I just don't get it. Some people are streaming movies. They're getting caught streaming movies, which is another big no-no. Some people are getting caught with first release. They're going to the theaters. They're taking videos of the films, and they're basically releasing on the internet. That's a big no-no. So you have to be very, very careful about these kinds of things. But the BitTorrent sites, what we call P2P, which is peer-to-peer file sharing in the swarm, where everybody's sharing, documents, books, software, things like Microsoft Office products and Autodesk products. I mean, you name it. Adobe, Photoshop products. I mean, people are just having fun. Apple products, Final Cut Pro, all kinds of things that, just about anything that can be digitized can be shared through these torrent sites. So these torrent suits, as we call them, some people call them trolls. Some people call them troll suits, but it's illegally downloading and sharing copyrighted movies. Okay. We've covered some of these other things. Sharing copyrighted videos without paying for them violates the exclusive rights of copyright holders. We'll talk about that in 1 second. But sharing the copyrighted videos of somebody else violates exclusive rights. So that's important. That's where we get into your infringement. That's when we start talking about infringement. Subpoenas to ISPs, again, are common, especially with the adult pornographic videos such as Malibu Media. They are filing lawsuits across the country. Last I checked, there was over 4,000 lawsuits. That's quite a few, basically, fighting you, trying to extract some money out of you for sharing their movies. As one of their attorneys told me, stop stealing our stuff. So, that's kind of how they look at it. So if you're faced with an ISP subpoena, we can help you. Give us a call. Again, we talked about this Dallas Buyer Club, London Has Fallen. Those are non-pornographic adult movies, but nonetheless, they're companies that enforce their intellectual property rights. We've talked about this in many other videos. When you create something, when you're a creator and you fix it in a tangible form, that's your copyright. And if you register your copyright, you get additional protections, such as the ability to bring a lawsuit in federal court, okay? So again, we have talked about this. It is important to teach your kids. If you're a parent watching this, a lot of people that watch it, even if you're a small business owner, you're probably also a parent. It's important to talk to your kids. Keep an eye on them. Don't let them download and share movies. If somebody comes to you, your kids, and say, hey, I just got this on Pirates Bay. You want to watch a movie with me? Get out the popcorn and the Skittles and the hot tamales. No, take a break. Say, wait a second, where is this movie coming from? What's the source? Who did you buy it? Did you pay for this? So forth and so on. So it's very important. Torrent lawsuits are on the rise. Okay, exclusive rights of a copyright holder. We talked about this. You can find this in 17 U.S.C. 106. No, that's not the U.S.C. Trojans. A lot of people go, wow, the U.S.C. Trojans write all the laws. No, that's the United States Code. United States Code. Okay, so whenever you create something, fix it in a tangible form, you become the copyright creator. Okay, the copyright holder. So I tell people sometimes, look, if I went and drew your picture and I drew a great picture and a cartoon photo of you or something, I have copyrights in that. When your kid draws something, your kid has copyrights. I mean, a lot of people don't get it. Your kid has created intellectual property. I mean, isn't that something? I think it's fascinating, which is why I studied intellectual property law in law school. So, but you have this content, this creative content that's protected the minute you put it into a tangible form, as long as it's not a fact or an idea. There's some limitations, but these things are protected by copyrights. What are the rights? Well, you get a bundle of rights, which is nice. It's not just one right. You get a bundle of rights. You have the exclusive right to reproduce that work, to prepare derivative works. In other words, to build something off your original. Now, when it becomes transformative, there's some other issues where maybe if somebody completely transforms your work, then they may be protected. So that's a whole nother issue. But you have the exclusive right to prepare derivative works. You have the exclusive right to distribute copies. You have the exclusive right to perform the copyrighted work publicly. That's number 4. Now, that's a big one. So if you write a song and you've got the lyrics, and you've got the rights to that, I mean, somebody can't go into the park and sing it and basically be charging tickets, okay? So now bear in mind on all these, and we'll talk about some of the defenses like fair use. Some other things come into play, okay? But you also have the right to display the copyrighted work publicly, display it, okay? And in the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. Okay, so there's lots of little stuff buried in here. Basic takeaway, just know you get a bundle of rights when you're a copyright creator, which is nice, and you can license those rights individually. You can give somebody the right to reproduce, you can give somebody else the right to perform. So it's really neat. This is where we get into copyright licensing and what you can actually do with your creative works. But let's move on. This PowerPoint is about infringement. So let's get back on topic. Willful copyright infringement. Now, this is normally what you are being threatened with when you get one of what we call the love letter, okay? When you get the love letter, it is telling you, we're joking, but they're telling you you're willfully infringing the copyrights. They have the rights to go after you for $150,000 per infringed work, per title, so forth and so on. But what is willful copyright infringement? That's when the plaintiff can hit the jackpot, so to speak, ring the bell, as we say in litigation, okay? So willful copyright infringement is infringement which is violating any of the exclusive rights of the copyright holder. We just talked about that. So infringement is violating their exclusive rights. Now, as I put here, the copyright holder will normally claim your company is a willful infringer, and they'll basically put the burden on you to say, no, it's not. I didn't steal your book. I didn't steal your music. I didn't download your film. I'm not sharing your protected software. You know, sometimes the Software Alliance will get in there and start calling you a willful infringer. We get a lot of those cases. Again, and you'll know the letter talks about $150,000 per infringement. Yes, that is staggering. We put that in a parentheses there. And willful infringement will also support a claim for attorney fees. So what you're always trying to do is get yourself out of this willful infringement argument, which is a net they do to basically just lasso and rope tie you and try to get everything they can out of you. So, but willful is a higher standard, but bear in mind it's not incredibly high, as I point out here. Let's go to the next slide. Willful infringement explained. Okay, note, willful infringement does not require a showing of actual knowledge. In other words, say, well, I had no idea. I had no actual knowledge of that. I did not know. Willful infringement does not require that. Okay, so that in and of itself will not save the day, so to speak. Okay. To prove willfulness, plaintiffs must show the infringer had actual or constructive knowledge. Constructive knowledge. There's your law exam. For you bar examiners that follow my podcast and my videos, thank you. Constructive knowledge. It means you don't have to actually have actual constructive knowledge. Knowledge is something you should know. You should have known that the infringing is and the infringer acted in reckless disregard. Reckless disregard, underline that, of the high probability that it was infringing plaintiff's copyright. So if you know, you don't know, you should know, and you're acting in reckless disregard, boom, that's going to get you there as well. Defendant's business practices and knowledge of the software industry and its licensing practices gave rise to an inference that the infringement was willful. So that was a software case. And, you know, there are some inferences that will arise when you're basically in an industry or you're the IT guy and you say, well, I didn't know. Well, come on. You've got knowledge of the industry practices. So if you're an IT director, CTO, chief technology officer, you know, you're going to be held to a higher standard and that's going to be used against you. Willfulness can also be established by reckless disregard for a copyright owner's rights. And we talked about that, reckless disregard, okay? Now, so that's what they're trying to prove. You're trying to get them off this notion of willful. Okay, maybe there is infringement. Maybe you did mess up. Maybe somehow inadvertently in these amazingly complex software licensing schemes, maybe you're short 2 copies. Maybe you can't find receipts. You know, so there's lots of different concepts and ideas, defenses that can be raised. You'd rather try to get this down to an innocent infringement where you're just, you know, hey, I missed it. I don't know what happened. Company was growing fast. We merged. You know, not a lot of things going on. So let's talk about this. The goal in raising defenses is to negate the intentional willful infringement allegations that they're making against you, okay? So you want to limit the scope of the damages if by fact you are found to be infringing. Example, not having the proper licenses for Microsoft Office, Windows. We have a lot of cases dealing with Microsoft Office. They really, really police that product. So you people should be aware. Check your Microsoft Office licensing. Make sure you're good, because what happens in those cases is they will unbundle the individual pieces of software and they will try to charge you for infringement of each. Trust me, the staggering and the demands on that get staggering. You won't like to see it. Cal Licenses, another one. And Autodesk. Autodesk Software, again, another company we deal quite frequently with. Quite a bit of policing of their Autodesk AutoCAD software, which is, you know, probably the most popular CAD program out there. And so the goal here, as I said, bullet point number 2, this may prevent them from wanting to sue you in the first place. You may have an opportunity to settle your case without going to court. So again, negating the intentional willfulness is very important. And I must point out, there is a fine line between criminal copyright infringement and it's what we could just would refer to as civil liability. So, when your infringement starts getting too high and it's intentional, then you may have something that a prosecutor will start looking at. So that's just something that we point out as well to think about, because there are certain threshold limits. We have information on our blog if you want to get into that. I don't want to do it today. Go to federalcopyrightlawyer.com and you can find some information about criminal copyright statutes and what those thresholds are. We'll leave you in suspense on that one. Also important to note, in willful infringement type cases, officers and directors may be held personally liable. That means if you are a CEO, a vice president, executive level, in CIO, chief information officer, and you should be knowing about these things. Officers and directors may be held personally liable. And we have different cases where, depending on the nature of the plaintiff and the software at issue, the amount, the value of the software, we have one software vendor right now that has an extremely expensive product creation software, product lifestyle software. I'm not going to name the company, but it's very, very expensive, and where you have basically use of crack codes or key generators to get at this valuable software with all its modules, the infringement can be very high, and you may very well see, in addition to these lawsuits naming lots of different DOE defendants, you may see them eventually going after the officer or the directors of the company to try to bring them in, especially if the company maybe is a startup. Okay, so you have maybe a startup that says, look, I really need this software, but I can't afford it. Tell you what, I need to develop my products. Why don't I use it? I'll use a crack code, key generators will get the software going. I'll download it off a torrent website, file sharing, and let's just use it. If they catch us, hey, fine, we'll go bankrupt. We have other articles about going bankrupt and whether you can just do that, but just bear in mind for this is if you're engaged in this, officer and directors could potentially be on the hook. Okay. Common responses. I'm gonna shift gears with you here. We were over here talking about torrent a little bit. I'm going to talk a little bit more about the software audits. Okay, we do a lot of these cases. These cases involve BSA, and if you know what that is, it's the Software Alliance, business software, and they're out looking for companies of all sizes, but we see a lot of mid-size, smaller to mid-size companies being approached for quote-unquote voluntary audits, and again, they are subtly referencing $150,000 in willful copyright infringement under the copyright laws, and so they are proceeding under that law. Now, this could be done by Microsoft. We also have on here the SIIA, Software Information Industry Association, and Autodesk, again, big ones. But it could be other companies. We have dealt with other companies with other products, so this is just a generalization. Some of the common things that pop up, again, to negate the willful infringement: you can't find your proof of service, you can't find your documentation, you have it, the records were lost, the management switched, the IT guys were out. Here's another one: companies merged and they acquired software. The companies merged, the acquired company had, unbeknownst to the acquiring company, was not aware that there was software infringement going on. So by the time you get in and you get everything managed, here you are getting a letter from BSA, and now you have a software audit. So things like that. And we have seen, by the way, some other things we've seen in other areas of litigation is where a acquiring company will acquire the assets but not the liabilities of other companies. So there could be some other types of indemnification issues that could pop up or in a merger case. Sale of a business case, there's other issues that can pop up. That's really where you need to get IP counsel involved, okay? So these are another thing, kind of negating some of the willfulness, if you can see that working. Heavy turnover of the IT directors, not sure who was doing what. Inadvertent sharing of disk between different departments. The marketing department and the business development department may be sharing disks, just not really thinking about it. Disks are lying around. Everybody's thinking it's fine. Sometimes you can have a disgruntled employee with one foot out the door installing the software. I don't know if I have that on my list, but this pops up as well because these BSA cases and the SIIA, they both offer rewards. They offer rewards, financial incentives for people to be basically whistleblowers and blowing the whistle on the company for software piracy. And so these people are incentivized. Now, you know how it is. We've all been at the job where somebody doesn't love the job and they're talking, I'm going to do something else with my life, and I've downloaded Rosetta Stone and I'm studying that on when nobody's looking. I'm studying that, and I saw an ad here on Facebook. Looks like I can report software piracy and rewards up to $1 million. I'm not lying, folks. Rewards up to $1 million. That's like a lottery ticket. So, somebody sees that and they go, I could probably put a piece of Autodesk on this computer here. Who would really even know? And report that. I mean, maybe I'll make some money. So there's all kinds of things. That's another one. A common example. You have OEM. That's legitimate software that you buy. For example, you buy a Dell computer and it's got Windows already loaded on it. And you say, well, that's part of the license. When I bought the original equipment manufacturer, when I bought their product, it had it already installed. I was buying the whole license. I got the whole license. And maybe you purchased this computer on eBay or Craigslist or whatever, lots of other different auction websites. And so you say, I'm good on these, and sometimes those licenses don't show in the audit. So it's another thing we look at, okay? Company growing too fast. I have here no SAM in place, software asset management practices, licensing techniques where you're making sure what you're using you're paying for, and having somebody that can actually figure out all the complexities of the software license, okay? So the company may have been growing too fast, not keeping an eye on the farm, people switching hands, you can see how if you start finessing all these factors, you can see that, boy, that sums up a lot of companies, doesn't it? So again, there's other problems. I've noted the problem of the keyword generators and the crack codes. Stay away from those. If we get audit results back with those, we know we're in trouble. I mean, because we just know. And the companies that call us, they just go, shit. We know we're busted on this one. So those are always a problem. Moving on, let's hit some defenses, some possible defenses to raise. One, I have a license. License means you have a specific agreement or legal rights that allow you to do what you're doing. For example, you have the right to make a backup copy. So whenever you're using software especially, you have to read the terms of the license to understand what you have. Because a lot of people say, well, I'll just install it here and there and everywhere. And what? It's just, and I brought some of the software over from my prior boss, and I just figured I was allowed to use it. You have to read the license, but you may have a license. Bullet point 2, we just talked about OEM, software that comes with your PC or your Mac. We've talked about that. Oral licenses. We had a case where somebody they said, here, you can use the software. Thank you for participating in our trade show. And I believe it was a speaker. We had somebody that spoke at the trade show, and they said, here, have a license. It's yours. And then they came back, and incredibly, they tried to hold my clients liable for that, and that didn't go down. So, that's another thing to look at. Lots of different factual situations. In laws, you'll find everything is based on the facts of the case. So that's another one to look at. Losing receipts, I can't find them. Just because I can't find them doesn't mean it's illegal. But that's another thing that pops up sometimes. Obviously, you want to keep good records, but if you can't find them, that may explain, may work as a defense, in other words. Final issue here, first sale doctrine. Sometimes people will buy software on the internet, and they'll say, I bought it legitimately on the internet. And you say, I have a license. And the software companies or whatever, if you're dealing with video games or movies, may say, you didn't check our licensing agreement. Our licensing agreement prohibits a sale. It's a license, and you can't be licensed without anything else. So the first sale doctrine is another thing to keep an eye on and take a look at. Okay. Number 2, I am not the infringer. We talked about this. Somebody else installed it. Somebody else used the digital content at issue. If it's a computer game, maybe it was a neighborhood kid installed it, came over and said, hey, let's hijack a video game here. So software. You may have hired a consultant you found on the internet, and they says, come in, and they said, yeah, I'll install some Autodesk for you. yeah, this stuff's all legit. Trust me, it's good. It's good. And they come in and they're using crack codes and key generators and getting you going, and you're paying them a fee, and you never hear from them again. In fact, you don't even know who they are. So things like that can help negate the willful infringement. The BSA or SIIA informant, as we talked about, installing for rewards. Okay, so that has to be looked at. Motives, that's information we try to get at. They won't always give it to you, but we do try to get down to that and figure out who that person is. Sometimes it's defamatory. Sometimes they're completely lying and they're basically slandering or libeling your company. It's defamation, okay? And sometimes, companies want to go after those people and stop them. Corporate sabotage. So also, I'm not the infringer. Software. Maybe you have a virus or a Trojan that installs software. That's always a possibility. You've seen these things where you go to these websites and it just sort of hijacks and takes your computer over. Those kinds of things, or you have things like My PC where you're getting tech support and there's somebody getting into your computer, looking around, and you don't really know what they're doing. I mean, you sort of keep an eye on them, but they work pretty fast. I always find it a little nerve-wracking when I'm working with somebody. I don't like them to get access to my computer. In fact, I haven't done it in a long time, just because it just makes me feel funny. I just, I don't know what all the things are on their end that they could be doing. Movies, you got these Bittorrent illegal movie download cases. Potential defense, I'm not the infringer, could be unsecured Wi-Fi. If your Wi-Fi, if you have wireless access at your house and somebody's digging into that, getting into that, maybe they're the ones doing the wrongful activity. Again, you have hackers. Photos, what do we have here? Third-party webmaster claims. Sometimes you hire a webmaster and it's your webmaster that promises they're going to do everything right and follow all the laws. They sign a contract with you and then they're using infringed photos. So that's always not a good thing. But if you're getting sued, you may have some indemnification rights against the third party. So those are other things we can look at, okay? Again, if you didn't do it, you can get sued. You could possibly have a cross suit for equitable or contractual indemnity. Moving on. Statute limitations, 3 years in civil, 5 years criminal. Latches, unreasonably delay in filing a lawsuit. These are some other defenses that may come up. Another one is the copyright is expired, that it's in the public domain. It's not on our chart here, but maybe the copyright has expired. Now, they last a long time, but maybe it's expired, another thing to look at, in the public domain, or maybe there's a Creative Commons license that allows you to do what you're doing. But statute limitations is something we always look at as litigation lawyers. Okay, fair use. This is another big one. Okay, fair use is basically, a copyright holder has their protection. They get their protection, but there is a defense of fair use. It's a 4-factor test. It's fuzzy. Courts apply all the factors. I'm going to try to nail it down for a second. Okay, if you're using somebody's copyrighted work in a non-commercial manner, and it's for scholarship, research, teaching, those kinds of things, it's just less likely that you can be held liable for infringement. Now, I always tell people never, ever rely on the fair use defense unless you're absolutely sure, because anybody can be sued for anything, and you don't want to be that person, okay? So, but if you have like student versions of software installed, that may be defense working with the Software Alliance. Hey, it was a student version. We just opened one file. It was just for research and study purposes. Non-commercial is always important. Movie clips, maybe in movie clips you say, well, the whole movie didn't even download. It was just a de minimis use, or it was one minute clip in a movie. It's like, give me a break here. De minimis is another potential. Here's one that I haven't heard anybody argue or raise yet, but just out of thought, what if you downloaded a movie on Bittorrent for scholarship and research purposes? I just want you to bear it in mind. I'll plant the seed on that. There may be an occasion where that actually pops up. I just got an email from somebody else the other day wanting stuff from me for research and stuff, and I said, well, that's interesting. Just got me thinking. Anyway, fair use, moving on. Parody, if you're making a parody of somebody else's copyrighted work, that can oftentimes work as a defense. Now, parody is tricky. And I have we will be coming out with when time permits, we will be coming out with a presentation on parody. Parody, as they say, is like shooting the king. You better be good at it, because if you miss, you're liable, and if you hit it, you're protected. So parody is a really interesting area of the law. I'll give you the nutshell of that, though. Parody must be making fun of or criticizing the work at issue. Satire is the opposite, and satire is when you're using the copyrighted work to make fun of something else. That is not as protected, if at all, okay? So that's important, but we'll do another show on that. That's a whole nother show. Again, courts look to all the factors, they apply the factors, and those people, the copyright holders that have the copyright, should not be sending DMC takedown notices before considering a fair use defense, okay? So it's very important, and that came up in a case. I can't remember the name of the case off the top of my head, but there was a case that you should consider the DMCA, the fair use, before sending the takedown, okay? And we can help you with takedown notices if you need that as well. Defense number 5, to willful infringement. Plaintiff did not register their copyrights before filing a lawsuit. That's a technical requirement. You can look that up if you want. I'm going to move on. First sale doctrine. We talked a little bit about this. The key case, if you want to get this, let's move it on. Werner versus Autodesk. Google that with Vondran, Vondran, and you will find my blog on that. But Werner versus Autodesk said if you were only granted a license, then you can't actually resell it. So that was a big case in software law, okay? And I'm going to pass on that. You can read that if you're interested. Copyright misuse. This is sort of technical. This sort of a lot relies on antitrust violations or some other, misuse by a company to extend its copyright beyond that which is entitled to. Okay, this is something that could pop up. I'm going to move it on here. Copyright misuse. It's there if you want to take a peek at it. Number 8, to willful infringement. Again, there's not a valid copyright. And I put here creative works of authorship. Are pornographic movies really creative? I mean, for me, they're all essentially the same. Dun 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 dun, and sexual acts, and there's your film. Thank you, everybody, for watching. Anyway, probably they're all protected by copyrights, but I just want to give you something to think about. Sometimes having some defense is better than no defense. Was it really fixed in a tangible medium of expression? And facts and ideas, those kinds of things are not protected, okay? Independent creation, this one popped up on in an Etsy case that we had. We had a client that was developing creative products, and a competitor said, "Hey, that's my product." And we said, "No, it's not. It may look like your product, but it certainly isn't your product. And by the way, you can't prove, and we can prove that this was independent creation. You can't prove that we accessed your work and copied it, and we can prove independent creation." So I have some law in here on that if you're interested in checking that out. Unclean hands, this is something that always comes up. This is a tough theory. It's something you always want to raise because there's oftentimes an element of unclean hands. Whether you can win on it or not, that's anybody's guess. But we're the other party, the plaintiff. Okay, the plaintiff in these Bittorrent lawsuits, or the plaintiffs, let's say, in a copyright infringement software case. They're alleging that you're doing things wrong, that you're the bad guy, that you're downloading these things, that you're a software pirate. That you're maliciously, damaging their business. So, but then you find, well, what if the movie producer or the software company were throwing out illegal access codes to be used for their software? What if they had a website that was actually putting that out there for you? Or in the case of, a case with like a Malibu Media case, if you have, and I'm not singling them out, but I'm just saying in general because they file a lot of these. What if they were actually out setting up third-party sites that basically seeded these movies so that the swarm could share them all, and they sort of were encouraging this activity? Something to think about. Like I said, I don't know if there's any cases that touched on this in that instance, but I have provided some case law here for you to look at if you think something like that may be up your alley, okay? Potential defense number 10, to willful copyright infringement. All right, that's it. If you made it this far, you know more than most people do about copyright defenses. We have more information out there. You have our phone number. We've helped small, medium, large companies across the United States and internationally. If you need help with copyright disputes, torrent downloads, bully cases, you name it. Or, as I put here as an example, if you're a company outside. I know Canada is a big area that's targeted as well for copyright infringement, and they're brought into California California courts such as the Southern District or the Northern District. A lot of technology companies are in the Northern District of California, Eastern and Central districts. So there's 4 districts in California. But if you're being pulled in, you need some help. We are a leader in software audits and licensing disputes. We have significant litigation and federal court experience. Make sure you check your attorney. If you're going to hire an attorney in this area, make sure they can prove to you their federal court experience. Like if you haven't been in a federal court, a lot of lawyers get a little shaky in the knees. They go, oh, it's, I'm not sure I know the federal rules of civil procedure, and I'm not sure how all that works, and the courtrooms are fancier, and the judges are appointed by presidents. I'm not sure I'm up for it, frankly. So make sure you have somebody with experience. Attorney Steve has experience, okay? Flat rate fees for many say that again. Flat rate fees for many non-litigation cases. So we make things affordable. We get you the representation you need. Here's some other resources for you. Again, federalcopyrightlawyer.com. We have some links to some of the big sites, the BSA, SIIA, and some other sites. But our main site for software audits is softwareauditlawyers.com. Our main site for copyright bully Bittorrent cases is copyrightbully.com. Okay, so you can find it all through our federal copyright lawyer. We really appreciate you listening, and if you like this show, feel free to share it on your social media networks. General legal information only. And again, we look forward to helping you. So you need some help, give us a call. Attorney Steve, thanks again.